The Factories Act 1937 provided the authority for the UK government to make regulations, including the Building Safety, Health and Welfare Regulations 1948, which said every side of a working platform or working place, being a side thereof from which a person is liable to fall a distance of more than 6 feet 6 inches, shall be provided with a suitable guardrail and with toe boards to prevent, so far as possible, the fall of persons, materials and tools from such platform or place. Harold Gill was a painter who was painting one side of a roof at an Air Force base in England. His ladder sloped up one side of the hut, and a co-worker's ladder sloped up the other side, and they joined in the middle. As the work progressed, they moved the ladders along. At one point, Gill leaned out to ask for help moving the ladder, and fell, injuring himself. He sued on the basis that he had been working from the ladder, and the ladder did not have guardrails or toe boards. The case came down to the question of whether the ladder counted as a working platform or working place so as to require those safety features. Lord Reid, considering this issue, said, "I find it necessary to make some general observations about the interpretation of regulations of this kind. They are addressed to practical people, skilled in the particular trade or industry, and their primary purpose is to prevent accidents by prescribing appropriate precautions. So they ought to be construed in the light of practical considerations rather than by a meticulous comparison of the language of their various provisions, such as might be appropriate in construing sections of an Act of Parliament." Lord Reid found that the ladder itself could not be regarded as a working platform or working place, and that it would have been impractical to put barriers around the whole roof. As a result, he found that the regulations did not apply. Accordingly, the employer was not in breach of the regulation. From this case, we learn that while regulations and other delegated legislation have the force of law, they cannot just be read as though they were statutes. They're often written in practical or industry language in order to enable them to be understood by those applying them, and the courts should construe them in that light.